Hello, everyone, and welcome back to Beyond the Evidence, the podcast where we dive deep into true crime cases, uncovering the facts and exploring the unanswered questions that keep us coming back for more. I'm your host, Marv, and I want to thank you for joining me today. If you haven't already, please subscribe to my YouTube channel and hit the notification bell so you never miss an update. And if you'd like to support the channel, you can find links to my PayPal and Cash App in the description. Now, let's get into today's topic.
Breaking all the patterns, facts and theories, clues and controversy, showing the journey, uncovering the mystery. This is Beyond the Evidence, where justice prevails, with Marv leading the way, truth never fails. Now get ready for this live stream. Superchat, highlight your message. Don't fall victim to the irrelevance. Hit that like, share, subscribe to Marv's Beyond the Evidence.
Hello, everyone. We are back. How is everyone doing? We are going to continue on with the second part of reading this document. We started last night, so if you missed that, go back and watch that one first. And then come to this one. Or come to this one, watch it, and then go back and watch part one. Hey, Karen, love seeing you too. Thanks for being here. Mustang's here. Lynette's here. I'll Be Frank is here. That's who's posted in the chat so far. Just so you all know, if we have any questions, I will be... Oh, I gotta do a new one. I'll be using Copilot today since I maxed out all of my... entries on ChatGPT because I haven't paid for it yet. So, like I said last night, when I have questions, I use ChatGPT, I use Copilot, and now I'm starting to use Gemini, which is the Apple version of AI to help. And I don't just use this in my YouTube stuff. I use this stuff in everyday life. Hey, Sean, nice to see you. All right. We left off on the bottom of page 15, and we have a total of 24 pages to go. So, let's take a look at this. All right. I'm not sure where he's been, Lynette. He's doing his own thing. So let's continue here. The question must be asked, therefore, why did Mullen and McClellan not immediately alert the defense that the Holder and Westfall and many other interviews were recorded over when the defense first asked McClellan and Mullen for those interviews in August 2023. All right, hang on 1 second. I got to close the door again because the cat just came in. Where are you? Get in here if you're getting in here. My door does not close all the way because my husband put soundproofing on it, and so she can open it, and she's a pest. All right. The defense has not seen anything other than an undated document and the words of McClellan and Mullen that support that the interviews were actually recorded over. This is not normal and is very troubling. Neither McClellan nor Mullen nor anyone else in the Unified Command has ever explained to this court, nor anyone else, why they did not immediately alert the defense that crucial evidence sought by the defense has been purportedly recorded over. Neither McClellan nor Mullen or anyone else has ever explained to this court, nor anyone else, why it took 5 months before providing a document detailing the claim of Mullen of what happened to those interviews. Those are 5 valuable months during which Richard Allen's counsel could have been investigating the actual claim that those interviews were recorded over. This is not normal. For 4 months, McClellan held on to exculpatory evidence he had in his possession from Todd Click's lawyer, including a certified letter detailing how a law enforcement officer was concerned, essentially, that McClellan may have the wrong man charged based upon evidence that he, Click, and 2 other law enforcement officers had gathered over a lengthy investigation that led them to believe that Holder and Fields and perhaps others were involved in the murders. Now, the defense keeps bringing up this over and over and over again, right? Things were recorded over, and in their terms, this evidence basically stated that in their terms, they state this is evidence that other people did this. Okay. Now they had the hearing. They had their chance to bring in whatever information and evidence that they wanted to the third party. They brought in Pearl Nutter. That was it. Okay. And that was all against the onus theory. They had opportunities during the trial. I was there. I heard it. I saw it. Judge Gull told them, if you can provide evidence of a connection between these individuals, the crime and the crime scene, then I'll allow it in. But not once did they ever produce any evidence connecting these individuals to the crime and the crime scene. They had theories on it, but theories are not evidence. And because it was only theories and no direct evidence, she didn't allow it in. Now, if you think that this is the only case that this is happening in, you're wrong. Go listen to all the new information that is happening in the Kohlberger trial. Same thing is happening. They want to bring in a third-party defense. That judge has said the exact same thing that Gull has said. You need to have a nexus, or it's not coming in. Not just theories. So, as this court knows from the Franks memo, including documentation provided to the court in that memo on May 1st, 2023, McClellan received through the United States Postal Service a certified mailing from attorney Paul Barada that detailed why his client, Todd Click, was concerned that McClellan did not have all the information necessary before making an arrest. The certified mailing not only contained a letter, but also the actual evidence that Click and law enforcement officers Kevin Murphy and Greg Ferenczi had gathered during their investigation. This included several videos that the prosecution had never turned over to the defense from the likes of Elvis Field, Rod Abrams, Ned Smith, and Johnny Messer. Again, in a normal world, this would be an earth-shattering mailing to receive if you're a prosecutor. Normally, this mailing would cause a normal prosecutor to immediately contact the defense lawyers by phone to alert them that the prosecutor had received this information and clearly was exculpatory. However, that did not happen. Instead, the prosecutor held on to the contents of that certified mailing for over 4 months. The prosecutor only turned those documents over to the defense after it became clear that the defense, would soon be learning of that certified mailing. In the August 10, 2023 deposition of Jerry Holman, the defense provided Holman and the prosecution with the 12-page Odin report, where the prosecution had to know that Click was a member of the investigation trio of law enforcement, along with Kevin Murphy and Greg Ferenczi. McClellan had to have understood that it was only a matter of time before the defense would learn from Click himself that he, Click, through his lawyers, had mailed a letter, much like Reese Davis, to the prosecutor with exculpatory evidence. McClellan's failure to immediately turn over the exculpatory evidence has never been explained to this court or anyone else. Why did it take McClellan over 4 months to turn over this evidence? Similarly, it took McClellan approximately 4 months to turn over the Reese Davis letters. Delayed discovery of exculpatory evidence without explanation is not normal, but has been a consistent pattern in this case. So I agree. Why is it taking so long to turn over this information? Why is the defense having to find out about it and then put the prosecutor on the spot in order to get it? With that being said, I just want to remind everybody that Click did go on the stand and state that they did not have any evidence in order to arrest these individuals. And that was done during that 3-day hearing. He did testify. He did testify of his thoughts and his theories, but admitted there was no evidence linking Brad Holder, Patrick Westfall, Elvis Fields, Johnny Messer, or any of the other ones to the crime. So once again, I'm just going to reiterate, you cannot bring in information into a court on theories alone. You have to have evidence. And what the defense is stating is evidence is not truly considered evidence under the law. And that's why it was not allowed in. But at the same time, he's right. There is a pattern with McClellan not turning this stuff over right away. Says, why in September 6, 2023, email to the defense did McClellan claim that the Purdue professor's identity was unknown and perhaps would never be known, when in fact, law enforcement had known the identity of the Purdue professor since mid-August 2023, if not before then? And why did the defense only learn of the Purdue professor's identity after the Franks memo was filed, calling out the prosecution for absurdly claiming it may not be able to learn his identity? Another perfect example. In my eyes, Nick McClellan did say that they probably wouldn't be able to identify him, and then all of a sudden his identity was released. In yet another example of what appears to be an attempt to conceal exculpatory evidence, McClellan has yet to explain to this court or anyone else why he sent an email to the defense on September 6, 2023, claiming that he and law enforcement did not yet know the identity of the Purdue professor, and more curiously, that they may never learn of the Purdue professor's identity. The Franks memo was filed on September 18, 2023. Coincidentally, the very next day, lo and behold, Jerry Holman actually found and interviewed the missing Purdue professor, Jeffrey Turco. Only 13 days earlier, it was thought that his identity may never be known. According to McClellan, but after the Franks memo, where the missing professor was discussed, he was found almost immediately. Let there be no doubt, the Purdue professor's report and even his October 19, 2023 interview revealed the murders may have been left behind sticks in the form of runes, consistent with the defense theory. This is called exculpatory evidence. Footnote. While Turco admitted in his report from 2017 that he could not confirm what the sticks represented, he also said the argument that these markings constitute an inscription inspired by Norse runes or modern recreation thereof is quite plausible. These words from Turco were not buried deep in the report, but rather in the very first paragraph. It would not be surprising if Holman or McClellan would want the defense to not have access to the report, as the report supported the defense theory that Norse paganists left the sticks behind in the form of runes. Okay, let's mix words, right? Let's get down to the nitty-gritty. Turco said it was plausible, meaning, let's see. Oop. The word plausible means something that is credible, believable, or reasonable. When we say something is plausible, we mean it seems likely to be true, or at least possible based on the available evidence or logical reasoning. For example, if someone presents a plausible explanation for a mysterious event, it means their explanation makes sense and could be true. Not that it is true. Could be. In his September 19, 2023 interview with Holman, Turco commented, I think the idea that somebody is trying to kind of replicate, early Germanic, rune script, that seems, I think, a given. Both the report and Turco's own words in his interview stray far from what Holman represented in his August 10, 2023 deposition as to what the Purdue professor's words were. Holman claimed under oath that the Purdue professor had stated that the sticks were not Odinism or any type of cult worshiping or any type of group that would have conducted the crime. Holman simply put misrepresented under oath the findings of the Purdue professor, who never said that the sticks were not representative of Odinism. Rather, the words the Purdue professor used was that the possibility was quite plausible and it was a given. I don't know that he stated it was a given, that it was absolutely true, but he stated that it was plausible, which it means it could be true. The defense believes that evidence supports that McClellan did not want the defense to learn the name of the Purdue professor, and thus the September 6, 2023 email that he, McClellan, has yet to explain Okay, that's kind of weird. Has yet to explain. Okay. Turco's report and interview supported the defense theory that Odinist Norse paganists were the murderers that left behind the runes at the crime scene. After Holman's September 19, 2023 interview of Turco, Holman prepared a report dated, because reports are normally dated, September 22nd, 2023, in which Holman admitted that he had known of the likely identity of the Purdue professor since mid-August 2023. If this is the case again, why did McClellan not disclose this information to the defense instead of claiming to the defense on September 6th, 2023, that the identity was unknown and may never be known? Again, McClellan has never answered that question to this court or anyone else. To the defense, it appears as yet another example of McClellan's attempt to conceal exculpatory evidence from the defense, much like the Reese Davis letters, and it is not normal. Number 4, why did McClellan fail to turn over the faked crime scene photo found on Holder's Facebook page, even to this day? And why did Trooper Roland Purdy twice swear under oath that the fake crime scene image was found on Brad Holder's Facebook page before the murders, only to then change his story on August 1st, 2024, at the hearing on third-party suspect evidence? As has been noted in the Franks memo and at various other times, the defense found among the massive amounts of evidence a report from Trooper Ryan Winters detailing evidence that suspect Brad Holder had an image on his social media pages that depicted two girls mimicking the very crime scene that law enforcement found on February 14th, 2017. Okay, let's talk about the photo. The photo had two women laying on the ground. Not in the same positions. They were in different positions. So wasn't the very crime scene mimicking the very crime scene? It wasn't. It was similar, but it wasn't the same. The image depicted two young girls lying on the forest floor with sticks branches on them, with one of the young girls' arms posed almost identically to that of Liberty German. This bizarre image had existed on Brad Holder's Facebook page before the murders, according to Trooper Roland Purdy. Why would Brad Holder, an early suspect, have such an eerily similar image on his Facebook page? Depends what you're into, is my guess. But that's not proof that Brad Holder had anything to do with it. Unfortunately, the prosecution failed to produce that exculpatory piece of evidence. The defense had to drive to Georgia to obtain that image from the very man, Ryan Boucher, who had located the image on Brad Holder's social media pages. Trooper Purdy, then under oath at his deposition in the fall of 2023, confirmed that the image was in fact on Brad Holder's Facebook page, but that he, Purdy, did not find the image compelling because it had been on Holder's Facebook page for a few years. On July 30th, 2024, Purdy once again confirmed under oath that this eerily similar fake crime image was found on Brad Holder's Facebook page. Then, very curiously, just 2 days later, Trooper Purdy recanted his two previous sworn statements, now claiming that he could not confirm that the image was on Brad Holder's Facebook page. Additionally, Trooper Winters claimed in his deposition that Indiana State Police could not locate the faked crime scene image that at one time was in the possession of the ISP post in Lafayette. To this day, the prosecution has failed to turn over said image. That is not normal. It is also not normal for a seasoned state trooper like Roland Purdy to retract 2 prior sworn statements during a hearing in which the mimicked crime scene image was a central piece of the defense's argument to allow third-party suspect evidence at trial. Okay, so for all of you who have been following me from yesterday to today, how is this photo direct evidence that these individuals were at the crime scene, on the bridge and the crime scene, to show that they are the ones that committed the murders? Does anybody have a response to that? Let's see here. No evidence, no third party. I believe there's one other person involved and only maybe, who knows? How much of the information did they receive that they didn't bother to examine because they were stuck on Odinism? That is a great question. Ari would have been arrested earlier if someone wouldn't have written his last name down as White House. That is the name of the street Ari lived on. That's my opinion. Well, more so, he would have been looked into sooner if they hadn't somebody hadn't written cleared on that. Repeat. Okay, my question is, the photo that was put on Brad Holder's Facebook, okay? How is that actual evidence for the defense that these individuals committed this crime? Because that's the question. The defense is trying to state that this photo is evidence which would allow the third party into the trial. Is it evidence? Because I don't believe it is. Okay. Video of Brad Holder and Westfall in pagan ritual in Fort Wayne. The defense was fortunate enough to locate among hundreds of thousands of documents a 2-page email from Greg Ferenczi to Tony Liggett dated December 12, 2018, in which Ferenczi describes a strange video that Brad Holder took of a pagan ritual in Fort Wayne, Indiana. Okay, not evidence. Not evidence. Right. Brad Holder was tape recording various people in the ceremony, periodically yelling out things such as "Hail Thor." At the very end of the video, Brad Holder tape recorded Patrick Westfall standing next to a tree and using his hand to seemingly mark something on the tree. In the email, Ferenczi commented to Liggett about Patrick Westfall marking the tree with his hand. This is significant because of the F found marked on the tree in one of the victims' blood.
A new station alert has arrived.
Law enforcement had believed that the tree was marked possibly by someone practicing Norse paganism or Odinism. The defense did not get a copy of this exculpatory video. Rather, it had to ask the prosecution for that video. Eventually, that video was turned over to the defense. It is not normal for the defense to continually have to request the prosecution to turn over evidence of an exculpatory nature that the prosecution has in its possession. Normally, the prosecution turns over the evidence immediately without any need to request it. This was yet another example of the state of Indiana holding on to exculpatory evidence before being forced to turn it over. So my question is, now this is the defense's side, is that the prosecution continually did not give them evidence. But we know for a fact that prior to the trial, they were asking for things from the prosecution stating they never received it, and the prosecution was having to go back through all the files and say, here it is, here it is, here it is. So what truly wasn't provided and what truly was? That's my question. All right. Conclusion and request. What has happened throughout this case is not normal. Prosecutors not turning over exculpatory evidence to the defense is not normal. Prosecutors holding on to exculpatory evidence until being forced to provide it to the defense by complaints from the defense is not normal. Prosecutors claiming that they can't locate a key exculpatory witness identity, a witness, mind you, that purportedly altered the way that the case was investigated, is not normal. How can the defense say that it altered the way the case was investigated? It's very obvious that this was investigated quite a bit, because otherwise you wouldn't have all this information. Having no explanation why a report that attempted to explain why key evidence is forever lost was not dated is not normal. Having a seasoned law enforcement officer recant 2 prior sworn statements concerning a key piece of exculpatory evidence that the ISP claims it cannot locate is not normal. Now, I don't know about this recantment. I'm going to have to look into that more. Finally, having a prosecutor claim in an email that he provided all the Reese Davis letters to the defense before trial, when just 14 days later, he was forced to admit that what he, McClellan, requested as truth in his email was in fact not true. This is not normal. Nor is it normal that one of the letters can't even be located and that the prosecution has no explanation for this missing Reese Davis letter. So, I'm sorry, but things get lost all the time. All the time. And it doesn't matter if you're in law enforcement, if you're in insurance, contracting, it does not matter. Things get lost all the time. So to say that it's not normal, yeah, it is. I lose things all the time. Paperwork, everything. My head, sometimes, I swear. It does not matter whether the contents of those letters can be questioned as unreliable. That is not for the prosecutor to determine. The prosecutor's only determination is to turn the evidence over to the defense. So I'm going to put in here, the prosecutor is to determine if, let me see, how do I want to word this? Information is exculpatory or not. If it is not exculpatory, does the prosecutor have to turn it over? All right, it says, in general, prosecutors are required to disclose exculpatory evidence, which is evidence that is favorable to the defendant and could potentially exonerate them or reduce their punishment. This obligation is rooted in the landmark Supreme Court case Brady versus Maryland, which established the withholding such evidence violates the defendant's right to a fair trial. However, if the information is not exculpatory, the prosecutor is not necessarily required to disclose it. The duty to disclose primary applies to evidence that is material to the defendant's guilt or punishment and could impact the outcome of the trial. There are also ethical and legal standards that may vary by jurisdiction, which can impose additional disclosure requirements on prosecutors. Okay, so if a prosecutor thinks the information is not exculpatory, but the defense does, who determines what it is? Okay, if there's a disagreement between the prosecutor and the defense regarding whether certain information is exculpatory, the matter can be brought before a judge. The defense can file a motion to compel discovery, requesting that the court review the disputed evidence and determine if it should be disclosed. The judge will then decide whether the information is material to the defense and whether it should be turned over. This process ensures that both parties have an opportunity to present their arguments and that the judge makes an impartial determination based on the law and the fact of the case. Does the judge have, or should the judge have a hearing to determine this, or can they make a decision based off the responses? Says in most cases, a judge will hold a hearing to determine whether the disputed evidence is exculpatory. This allows both the prosecution and the defense to present their arguments and any supporting evidence. During the hearing, the judge will listen to the points raised by both sides and may also review the contested information in question. However, there are situations where a judge might decide to make a determination based on the written submissions from both parties without holding an in-person hearing. This decision largely depends on the complexity of the issue and the judge's discretion. Well, we all know Judge Gold does not like to hold hearings. So she just denies things. And she denies them without giving a written explanation of why she denied it. And I think that is one of her biggest faults in this case, and has been. And I'm not afraid to say that. Okay. And the defense is right that they should have the opportunity to determine the value of the information contained in the letters. It does not matter whether those letters may conflict with other defense theories, as the defense has the constitutional right to possess all exculpatory evidence and then to determine how it should proceed strategically in the defense of their client. A local Carroll County rule also requires turning over said evidence. The fact is that the prosecution had in its possession letters in which a key suspect, Keegan Klein, purportedly confessed to the crimes and provided details that only the killer might know. And the information should have been provided to the defense. Because of the prosecution's failure to produce those letters, and because the prosecution had a history and pattern of not turning over exculpatory evidence, Richard Allen deserves another trial. Now, here's my opinion on that. This all needs to be brought onto the record, which is what the defense is doing. I understand that. And then when the appellate lawyers do the appeal, they're going to put all of this information into their appeal also. But first, it's got to be put on the record in order to get into the appeal. That does not mean that the Supreme Court is going to find that this information was exculpatory. They may or they may not. So this is another reason why I want it to go to appeal, because I want those judges to have to be accountable and tell us what was right, what was wrong, what was done incorrectly in the trial. If the judge was right in saying this was not exculpatory and not allowing it in. It's holding the judges accountable and Judge Gull accountable, along with both attorneys. And I think that's the only way we're finally going to get an answer as to what is right and what is wrong. I'm not perfect and have made mistakes. I also believe for 5 years that Ellie tried to find evidence on those players and couldn't. Yeah. To me, it's just another last-ditch effort by Baldwin. Baldwin's still butthurt over Doug Carter calling him out in public. I see it in every interview Baldwin does. Interesting. Okay. Let's keep going. We're getting there. Richard Allen, through his counsel, therefore seeks a hearing in which the prosecutor is requested to explain why he failed to turn over the Reese Davis letters, why he misrepresented his possession of those letters to defense counsel in his February 13, 2025 email, as well as to explain the other examples of failing to turn over exculpatory evidence as recited herein, which shows a pattern of such conduct. The defense seeks such a hearing in order to, 1, use the state of Indiana's answers to these questions in a renewed motion for new trial based upon newly discovered evidence. Well, most of what they have is not newly discovered evidence. These recent Reese letters would be. 2, in order to use the state of Indiana's answers to those questions as a record that can be utilized by the appellate lawyers should the court deny Allen his request for a new trial. And I just said that. Lastly, Allen asked this court to order sanctions against the state of Indiana for violating the Carroll County local rule concerning exculpatory evidence. The sanction the defense is seeking is ordering a new trial. Of course it is. I swear and affirm that the statements contained in this memorandum are true and accurate to the best of my knowledge. Andrew J. Baldwin. Yeah, Rosie hasn't put in an appearance. He might be helping behind the scenes, but I think he's moved on. Okay, those receipt letters are hearsay. I've heard about this too. So I'm going to ask Copilot, what are the exceptions to the hearsay laws for court cases? Hearsay is generally inadmissible in court because it involves statements made outside of the courtroom that are offered to prove the truth of the matter asserted. However, there are several exceptions to this rule, which allow certain types of hearsay to be admitted as evidence. Here are some common exceptions. Present sense impression. A statement describing or explaining an event or condition made while or immediately after the declarant perceived it. Excited utterance. A statement relating to a startling event or condition made while the declarant was under the stress of excitement caused by the event. Then existing mental, emotional, or physical condition. A statement of the declarant's then existing state of mind, emotion, sensation, or physical condition. Statement made for medical diagnosis or treatment. A statement made for the purpose of medical diagnosis or statement describing medical history, symptoms, or the cause of the condition. Recorded recollection. A record that was made or adopted by the witness when the matter was fresh in their memory and accurately reflects their knowledge. Records of a regularly conducted activity. Records made in the course of a regularly conducted business activity, provided certain conditions are met. Public records. Records or statements of public offices or agency that set forth the activities of the office or agency, matters observed pursuant to a duty imposed by law or factual finding from the investigation. Okay. In the Delphi murders case, there is a witness. No, there is an individual that has come forward with some alleged confessions of an individual who is now deceased. Can this information be used with an exception to the hearsay rule? In the Delphi murders case, the alleged confessions of an individual who is now deceased could potentially be used under certain exceptions to the hearsay rule. One relevant exception is the statement against interest exception. This exception allows for the admission of a statement made by a person that was so contrary to their own interest at the time it was made that a reasonable person would not have made the statement unless they believed it to be true. This can include statements that would subject the person to criminal liability. Another possible exception is the dying declaration exception, which applies to statements made by a person who believes they are about to die concerning the cause or circumstances of their impending death. Well, we know that one is out because he did not make these supposed confessions on his deathbed. The admissibility of such statements ultimately depends on the specific facts of the case and the judge's discretion. The defense and prosecution would likely present arguments regarding the applicability of these exceptions, and the judge would make a determination based on the evidence and legal standards. So, by Judge Gull denying all these motions with this different information, she is agreeing with the prosecutor that it is not exculpatory. Okay? And therefore, the prosecution was not in the wrong. Now, because she hasn't held her hearings on all this, and she's only going by their statements that is written to the court, is she wrong? She could be. But once again, that's where we need the appellate court to come in and say she was wrong. Because we're not lawyers. We don't know. Her job is to follow the law. The prosecutor is saying it's not exculpatory. She's saying it's not exculpatory. So now it needs to go further up the chain in order to determine if it is or isn't, and whether it should have been allowed in the trial or it shouldn't have been allowed in the trial. But the main question is, if this had been allowed in the trial, would it have changed the juror's mind and their decision? That is the main question. If they come to the determination that they do not believe that this information would have changed the juror's mind and decision, it's over. There is no new trial. The only way they are going to make the taxpayers pay for another trial is if they believe this information would have concretely changed the juror's mind. Does that make sense to everybody? But like I said, we don't know. So we need the appellate court to take this on and look at it and tell us what was done right and what was done wrong. I don't find them credible either. I mean, I did a live where I showed what the polygraph results were, what it meant. He failed miserably. And I would love to know now, in the other documents we received prior to this, there was a statement stating that he continually, Reese Davis, continually contacts prosecutors, not just this prosecutor, prosecutors on different cases, trying to provide them information. If this is true, then Nick McClellan needs to get that, and he needs to show it in court or in his response. Now, the last motion, Gull denied before Nick even made his response. This time, I think she better wait and let Nick make his response. And I'm telling you, she needs to have a hearing on this once and for all, like she should have been in the past. But as I said yesterday, she is done with this case. She doesn't plan on doing anything with this case unless the appellate court forces her hand. And that's sad because this all could have been done correctly. The hearings on the different motions and memorandums, if she had held it, would have supported the record for all of this, for all of her decisions. And that's the worst part. So now, once again, the families are in limbo. They're having to listen to all this crap when they thought, I mean, I'm sure they knew that these attorneys were going to appeal. You know, they knew that. But now it's just more wait and see what happens. So how long is this going to drag out? 2, 3, 4 years? So nothing's ever going to be finalized for those families until this goes in front of the Supreme Court, in my opinion. And that's a shame because they want to grieve the girls. They want to grieve Abby and Libby, and they want to start to heal and move on. But they can't do that. Not with all of this up in the air. And I truly do believe that with everything that has gone on with the trial and everything else, the loss of these 2 girls' lives has been pushed down so much, it's not even funny. What mattered to them and the fact that they should still be here today and that they lost their lives at the hands of another has been overshadowed by the rights of now a convicted killer. And that's the saddest part of all. Yeah, it is very backed up. Right. And the worst part is that he's stated that he wants to apologize to the families. Well, that can't be true if he's willing to let his attorneys keep doing this and appeal the conviction. And from my understanding, he got moved to the new prison. He's still having issues, even in the new place. So, what is going on? And I'd love to know exactly what issues he's having. And if he's still confessing. That would be an interesting answer. Is he still there confessing to the murders of Abby and Libby? Because if he is, the defense has a real problem. So what are your guys' thoughts on all of this? I mean, from what I can see, a lot of you that are in the chat that are talking think this is a last-ditch effort by the defense. I know that I have people watching that are for Richard Allen. What are your thoughts? On the questions that I asked earlier. Is this evidence or is this a theory? Things like that. Let me know in the comments below. Would love to know what you're thinking. All right. This is the end of Delphi until we get a response from the prosecutor or the judge. We're waiting. I'll make sure that when that comes out, I will give you the information so that you're informed of what's going on. Tonight I have to go to a fundraiser, and then I need to do a test with Andrea today before that on the members only live. So tomorrow I am going to do a members only live. And that just reminded me, hang on a minute here. All right. Let's see here. It's the beginning of the month. So I have memberships back. And I've just gifted 5. Looks like Lynette, Justice Angel, Judy Holiday, the Silver Leaf, and the Royal We have just been given memberships. So congratulations. Tomorrow's members only live is going to be about Casey Anthony returning to social media and how and why people are upset about that. So join me tomorrow night for that. And in between tonight and the members only live tomorrow, I'm going to try to get out a couple of quick videos on some missing kids from Wisconsin here. And I'll be continuing to do those quick little videos on different missing cases going forward. So if you have a missing person's case that you want me to profile, email the information to me to beyondtheevidence1@gmail.com. And with that, I'm working on an update for Harmony Montgomery. And there's going to be I'm going to continue with the Tabitha Shuck Rains series and finishing the book. And then Andrea and I will figure out where to go from there. And then I'm going to be bringing in a new case to you guys also. So lots of things coming up. Make sure that you hit that bell icon and the notification so you know that when I'm coming on air. And I always put it in the Discord and in the Facebook group. So, oh boy. Yeah, Lynette. Oh boy, Casey Anthony. She's evil. Exactly. All right, everyone. I hope that you guys have a good rest of your Friday. And I will see you tomorrow if you remember. And we'll talk then. Have a good day. Bye.